Now, the reasons for eviction, usually twofold. Either non-payment of rent is the most straightforward. The other is breach. A breach can fall into a number of different categories: disruptive resident or even a visitor, health, safety, welfare of others or self, failure to abide by the resident's rules and regulations, or breach of residency agreement obligations. And I wanted to talk a little bit about some examples here.
Well, we find most of the time the situations that arise are not the easiest to handle. For example, if it's a non-payment of rent, that's pretty easy. The courts are used to dealing with this. This is a typical, traditional landlord-tenant issue. What we have in assisted living, though, are usually behavioral-based problems or other similar-based problems. And it requires much more documentation on the part of the assisted living because we have a very uphill battle once we get into court to show the judge why eviction is the only reasonable alternative here. So it takes typically more than one circumstance. It takes repeated circumstances. We have to show very clearly how the behavior oftentimes impacts other residents and threatens their ability to peacefully enjoy the environment. It's also very critical in the documentation trail that we present to the court that it's clear that the resident understood when they came in, then the family, the responsible person, the rules they had to abide by, that it's referenced in the residency agreement, that they're given copies of handbooks, and that the terms and the explanations in the handbook are easy to understand so that the resident really has full and effective notice of what they could do that would result in them being evicted from the residence.
And probably one of the more difficult breach terminations that we deal with is when a resident who initially arrived and was appropriate for an assisted living facility over time becomes an inappropriate placement there because they require care that's beyond the scope of that which the facility is permitted by law to provide. And those, again, as Diana pointed out, are really dicey because you've really made a change or the resident has changed while they're at the facility, and the documentation of that is so critical to be able to get before a judge ultimately to convince them that this person is otherwise well-behaved, paying their bills, yet legally the facility cannot keep them at that facility. It's a tough argument, and it's very important to get documentation on that.
And when we talk about documentation, it's not just facility documentation. You know, when other residents or other visitors will give statements about whether they were fearful or whether their peaceful enjoyment has been invaded, those types of third-party statements can be very helpful in that process.